Hello everyone. In this presentation, we will see whether blameworthy mental condition has a role to play in fixing tortious liability. We have seen that in order to make a person liable for tort, he must have violated the right of the plaintiff or must have breached a duty imposed by law which resulted in damage to the plaintiff. Here the question would be, should it be proved that the defendant had violated the right or breached his duty intentionally or negligently? That is, should liability be based on fault? Here again, there are two theories, one put forth by Salmond and one put forth by Wigmore. According to Salmond, liability should always be based on fault. According to this theory, the defendant should be held liable only when the wrongful act is done either intentionally or negligently. It would not be just to make a person pay damages to the injured party if the act causing injury was done without intention or by accident. The other theory states that rudimentary principles of law began by making a man act at his peril, and gradually it evolved and became moralized when the liability was based on fault. Now, both these theories do not seem to be entirely correct. The law aims at protecting two basic interests of an individual: his interest in security and his interest in freedom of action. And here arises the conflict. In order to protect the interest in his security, the person who was responsible for injuring his interest has to be made to compensate for it, irrespective of fault. And in order to protect the interest in his freedom, the person harming it should be made to compensate only when he does the act intentionally or recklessly, that is, without caring about the interest of others. In 19th century, liability rested on negligence, whereas from 20th century onwards, the tendency has been towards laying down principles of strict and absolute liability. For example, Motor Vehicles Act provides for compensating the injured party and their dependents immediately without insisting on proof of fault. Here, the liability is no fault liability. But when the plaintiff sues the defendant, he can claim additional compensation for the loss suffered by him on the principle of fault. Thus, the essential conditions of tortious liability are act or omission on the part of the defendant, done intentionally or negligently or in breach of strict duty by the defendant. The act or omission results in damage to the plaintiff, which is not a remote consequence of the defendant's conduct. That is, there has to be a cause and effect relationship established between the act of the defendant and the injury suffered by the plaintiff. Here, an act is something that is controlled by human will. That is, it involves willed action or voluntary action by the defendant. He can also be liable for voluntarily or willfully omitting to do an act when the omission is illegal. That is, where the law imposes a duty upon him to do the act and he omits doing it. The act must be done intentionally, negligently, or in breach of strict duty. He is said to have done the act intentionally when he does it with a desire to bring about the consequences. When the act is done voluntarily, the man is deemed to have desired the natural and probable consequences of the act, and hence he would be said to have acted intentionally. Regarding negligence, it is used in two different senses: one as a state of mind and two as a specific tort. When used in the first sense, it is a state of mind which, when present while doing an act, would make a person liable under certain circumstances. In such a context, it is doing an act without exercising proper care and caution, which a reasonable man ought to have exercised in the given circumstances. Example, negligent handling of explosives causing loss to the property. Though he does not desire to bring about the consequences, he does not care about the consequences. When he is careless, he does not realize the consequences because he does not give a thought about what he is doing. Where he does not desire to bring about the consequences, but he is aware of the consequences and also knows that he is exposing others to the risk of it, he does it with conscious and advertent negligence. Negligence does not denote want of skill, but when a person voluntarily undertakes doing an act which requires certain special skill which he does not possess, he is said to have acted negligently. When A knows that he is just learning driving and cannot drive a vehicle on roads with heavy traffic, but undertakes driving a school van and an accident occurs resulting in injury to two children, he would be liable for his negligent act. But where a cleaner of the school van who is learning driving has to take up driving because the driver suffered a stroke while driving and in the course of bringing the vehicle to a halt, hits the footpath and causes injury to two children, he cannot be held guilty of negligence. Thus, where a person deficient of a special skill is placed in such a situation without his choice, that is involuntarily, where exercise of that skill is essential for the safety of others, he is not guilty of negligence just because an ordinary man would have successfully avoided the harm. In torts, a reasonable man is an ordinary average man in a society. Reasonable conduct is the behavior of an ordinary man in the given circumstances. Reasonable man and reasonable conduct are the yardsticks with which the conduct of the defendant has to be measured in a tort. Motive is also a state of mind which inspires a man to do an act. It is the object that is intended to be achieved by doing an act. A person steals money from B to feed poor children in an orphanage. Here, A intends to cause wrongful loss to B, but he does this to feed poor children. Here, the motive, that is to feed poor children, is good, but it is not taken into consideration for fixing liability for a tort or a crime. A lawful act will not become unlawful because it is done with bad motive, and an unlawful act will not become lawful just because it is done with good motive. But motive is relevant as an ingredient in torts of malicious prosecution, maliciously abusing the process of court, defamation, conspiracy, and nuisance. Malice is another form of blameworthy mental condition in torts. In ordinary sense, malice means ill will, spite, or improper motive. But in legal sense, it means doing a wrongful act without any just cause or excuse. Thus, malice can be malice in fact, where it means ill will or spite, or malice in law, where it means doing a wrongful act without just cause or excuse. Malice in fact is generally irrelevant in torts. Finally, the damage caused to the plaintiff by the defendant's act should not be too remote a consequence of the act. It has to be immediate or proximate cause. Before holding the defendant liable for the tort, it has to be proved that the injury suffered by the plaintiff was the consequence of the defendant's act. That is, the cause and effect relationship between the act of the defendant and the injury suffered by the plaintiff has to be established. Is it always necessary to prove actual damage in order to hold the defendant liable for tort? In case of torts actionable per se, the wrongful acts are actionable without proving actual damage to the plaintiff. For example, in trespass, where A enters upon the property of B without B's permission, A commits trespass and B need not prove that he had suffered any loss due to trespass. But in torts, which are not actionable per se, the plaintiff has to prove that the damage has been caused because of the wrongful act of the defendant. Thus, in the case of malicious prosecution, it has to be proved that the prosecution initiated by the defendant against the plaintiff was false and was with malice, that is, done with an intent to cause injury, which in fact has resulted in harm to his body, mind, reputation, or property. The terms malfeasance, misfeasance, and nonfeasance are frequently used in torts, and it is necessary to understand what they mean. Malfeasance is committing an unlawful act which is actionable per se. For example, torts of libel, trespass, etc. Misfeasance is doing a lawful act in an improper manner, and nonfeasance is omitting to do an act when there is a duty imposed by law to do it. Generally, statutory bodies, that is, bodies created by statutes, are not liable for acts of nonfeasance, but where the statutory obligation is imposed upon a statutory body to maintain roads, clear garbage, etc., the statutory body will be liable for nonfeasance. When a structure is brought from outside and placed on a highway, and the public body neglects maintaining the structure in good repair, resulting in a bodily injury to a person, he would be entitled to sue for damages. For example, a huge clock suspended on a clock tower, which is supposed to be maintained by municipal authorities, is not maintained properly, because of which it breaks and falls on A, who was walking on the road. The municipal authorities would be liable to pay damages to A for the injury suffered by him. Where a nonfeasance causes public nuisance, action can be initiated on proof of particular damage. In India, the public authorities are liable for nuisance which arose due to nonfeasance. So far as law of torts as in force in India is concerned, generally the principles of English law as suitable to the Indian conditions are applicable, and wherever necessary they are modified by acts of parliament. The law of torts was introduced through British courts set up in India under British rule. The English law of torts is based on English common law. Now, what is English common law? It is law that is primarily developed by the judges and is based on precedents and judicial decisions, that is, decisions of higher courts, which in turn most of the time are based on customary law and practices. Statutory law, on the other hand, is the law based on acts made by the parliament. The law of torts in independent India is not as developed as it ought to be because of various factors like poverty, lack of awareness of rights among people, expensive and dilatory judicial system, and indifferent attitude of people which keep them away from approaching the courts for seeking redress for violation of their rights. Though law of torts is not completely codified, steps are being taken by the Indian Parliament to enact laws covering certain aspects of tort law like Motor Vehicles Act, Consumer Protection Act, Fatal Accidents Act, etc. The Supreme Court of India is also evolving new principles and laying down new norms to deal with new problems arising in industrialized economy. For example, the principle of absolute liability was evolved in the place of principle of strict liability in MC Mehta versus Union of India to deal with new situations in the society due to modern industrial development. Here, the defenses available to the defendant under the rule of strict liability, like inevitable accident, etc., will not be available, and hence the liability imposed on the defendant would be absolute. Thank you.